Let's dive right into this explainer and look at a truly powerful moment in South African legal history. We're talking about the year 2000 Constitutional Court judgment, widely known as the Dawood case. It's this incredibly fascinating story about what happens when the rigid, cold gears of immigration bureaucracy slam right into the fundamental human right to family life. Honestly, it's a perfect example of why we even have constitutions in the first place, to protect everyday, regular people from the unchecked power of the state.
Picture this for a second. You're happily married, you're building a life together, maybe even raising a kid. And then, out of nowhere, you discover a bureaucratic trap that demands you either pack up and leave your family or face actual criminal charges. Sounds like the plot of a dystopian novel, right? But for so many South Africans married to foreign nationals back in the late 1990s, this wasn't fiction. It was their daily reality. The law essentially created this nightmare scenario where staying in the same house as your husband or wife could make you a criminal.
Section 1. An impossible choice. 3 families divided.
To really grasp the heavy constitutional crisis at play here, we have to look at 3 real couples who found themselves trapped in this exact nightmare. First, you have Mr. Dawood. He's a South African watchmaker, making a modest living, married to a Thai national. They literally just had a newborn baby, and suddenly they're hit with a demand for a massive fee just to apply to stay together. Then there's Mrs. Shalabi, a local staff nurse. Her Egyptian husband was abruptly told he was quote-unquote illegally in the country and ordered to leave, even though they shared a child. And finally, Mrs. Thomas, a clerk. Her deep-sea fisherman husband from St. Helena lost his job, so the government just refused his permit and ordered him out. 3 totally different families, right? But they were all facing the exact same crisis.
All of them were backed into a brutal catch-22. It was literally separate from the person you love or break the law by staying in South Africa while waiting for permanent immigration papers. The system demanded that the foreign spouse physically leave the country to apply for permanent residence from the outside. If you stayed inside the country without a valid temporary permit while your paperwork was processing, you were committing a criminal offense. It was just an impossible choice.
Section 2. The bureaucratic trap. The Aliens Control Act.
Okay, so how did this trap actually work? The crucial thing to understand here is the mechanics of the law itself, and what's deeply ironic is how a rule that was supposed to be a helpful exemption actually became the snare. Generally, the law said you had to be outside South Africa to apply for an immigration permit, but Section 25(9)(b) created an exception specifically for spouses. It said, sure, you can apply from inside the country, but only if you have a valid temporary residence permit. Sounds reasonable enough at first glance, doesn't it? But as always, the devil is in the administrative details.
Here's exactly how families were derailed by bureaucratic red tape. Step 1. A spouse applies for permanent residence. Step 2. Because the government backlog is massive, their temporary permit naturally expires while they're just sitting there waiting. Step 3. They go to an immigration official to ask for a simple extension, but the official just arbitrarily says no. So suddenly, they no longer hold a valid temporary permit, which means they instantly no longer qualify for that inside-the-country exemption. And Step 4. Deportation. The system was basically designed to set them up for failure.
And to make matters worse, a completely non-refundable fee of 7,750 Rand was introduced. That was later bumped up to over 10,000 Rand. This flat-out blocked poorer families from even applying. I mean, think back to Mr. Dawood, the watchmaker, earning 3,000 Rand a month, or Mrs. Thomas earning just 2,000 Rand a month. A fee that high was completely out of reach. If you couldn't pay it, your application wasn't processed. If it wasn't processed, your temporary permit wasn't extended. And if it wasn't extended, you were deported. It was a reality where wealthy families could effectively buy their right to stay together, while working-class families were just torn apart.
Section 3. The right to dignity, more than just law. So, how do you fight this legally if your country's constitution doesn't explicitly have a clause protecting the right to family life? Well, if we look at international human rights law, it absolutely recognizes the importance of the family unit. Big foundational documents like the Universal Declaration of Human Rights and the African Charter mandate that the state must protect the family. But here was the major hurdle for the lawyers representing these couples. The post-apartheid South African Constitution didn't actually contain a specific sentence that said everyone has the right to family life.
However, South Africa's constitution bridged that gap brilliantly by relying on Section 10. This section asserts that human dignity is a fundamental, enforceable right. The Constitutional Court looked right at the foundation of the country's democracy and said, look, human dignity isn't just some nice philosophical idea. It's an active, enforceable legal weapon designed to push back against a past where dignity was routinely denied. And really, what is more central to your human dignity than the right to marry, cohabit, and build a life with the person you love?
Justice O'Regan articulated this perfectly. She described how forcing spouses apart directly violates that right to dignity by destroying their reciprocal community of life. She made the point that marriage is so much more than a piece of paper or a legal contract. It establishes a profound personal relationship. By giving random immigration officials the power to arbitrarily refuse temporary permits, the state was effectively claiming the power to destroy that community of life. Denying spouses the right to live together is just a direct, undeniable assault on their human dignity.
Section 4. The unchecked discretion, the core flaw.
Now let's pivot to the core legal flaw that actually allowed these violations to happen in the first place. In any system governed by the rule of law, if an official is going to limit a massive constitutional right like your dignity, they absolutely need strict guided rules on when and how they can do that. We call that guided discretion. But the problem was, the Aliens Control Act gave immigration officers unchecked discretion. It provided literally zero guidance, no checklist, no criteria whatsoever on when it was okay to refuse a permit.
Because of this total lack of legislative regulation, officials could just routinely deny extensions. The law simply said officials may issue or extend permits. It didn't tell them they had to consider if the applicant was married to a South African citizen. It didn't tell them to consider the impact on young children. What it did do was place a massive, unfair burden on busy and often legally untrained immigration clerks. They were somehow expected to navigate complex constitutional rights on their own. This led to a huge risk of arbitrary decisions where families were separated and didn't even know what criteria were used to kick them out.
Section 5. The landmark ruling, fixing the flaw.
So what happened next? How did the Constitutional Court step in to stop this bureaucratic nightmare? Well, they mapped out a brilliant timeline. They struck down the unconstitutional law, but they gave Parliament 24 months to draft a proper replacement. Justice O'Regan made it clear it's not the court's job to rewrite immigration law. That's Parliament's job. But at the same time, they couldn't just sit back and let families suffer for 2 years while the government fixed its mistakes. So they instituted mandatory interim relief right then and there.
This interim fix was a real game changer. The court handed down a strict mandate. They basically looked at the Department of Home Affairs and said, if a foreign national is married to a South African and they're applying for permanent residence, you must extend their temporary permit, period. Unless you can prove a legally valid good cause not to. No more unchecked discretion. No more arbitrary stamps.
And they made sure to define exactly what good cause meant. We're talking serious criminal offenses, posing a real, tangible threat to the public, or if the person was just flat out refusing to submit their paperwork in a reasonable time. If those things were happening, sure, the state had good cause to refuse. But simply lacking a transit to holiday conversion or just getting caught up in a massive government backlog, that was no longer good cause. The families won. The Dawoods, the Shalabis, and the Thomases were finally legally allowed to stay together.
So as we wrap up, I want to leave you with this question. How does the Constitution protect the most vulnerable from unchecked power? The Dawood case is such a powerful reminder that human rights aren't always about massive, dramatic events on the world stage. Often, they're about making sure a simple government form or a clerk's unchecked stamp doesn't have the power to rip a loving family apart. By demanding that the law provide clear guidance, the court proved that human dignity isn't just some promise written on a piece of paper. It has to be a reality in practice. So what other areas of our daily lives might still be hiding unchecked power like this? It's definitely something to think about. Thanks for joining me on this explainer, and I'll catch you next time.